Good afternoon, everyone. I'm Joe Barocchi, a partner at Weber Gallagher, being joined by my co-pilot for today's voyage, Vanessa Mendeleski. We're here today to talk to you about some issues in regard to Section 20. One of the things that we wanted to do when we started this process was come up with something a little bit different. So since I'm stuck in the 80s, and I'm also a sports guy, I figured I would follow the pattern of two different shows that happen on a major sports channel. One is 30 for 30 and the other one is Pardon the Interruption. So our purpose of today is to take you on the journey of 20 for Section 20. Section 20. As they said in Van Halen back in the 1980s, everybody wants one, how about you? Funny, that since we're stuck on that, David Lee Roth is 63 years old and Eddie Van Halen is 62. More important though is, while everybody wants one, to quote Mick Jagger, you can't always get what you want, but we'll try to get what you need. And Jagger's 74. Can you imagine rocking still at 74? Section 20, what is it and why do you want it? Number one, Section 20 is a statute. It was drafted by the legislature and it's designed as a way to resolve disputed claims on a lump sum, full and final basis.
And in order to get a Section 20, there's certain requirements that have to be met and considered by the court. And we'll be discussing those a little later in our 20 for 20. And there's an actual citation with regards to this because it's statutory. It's NJSA 34:15-20 as noted on the screen.
Number two, Section 20 is a type of settlement. As many of you might be aware, but some of you might not, there's two different types of settlements in New Jersey. One is an order approving settlement, and that's where there's basically no dispute on the claim. The only dispute is the level of permanent disability. In a settlement under an order approving settlement, the injured worker would have rights to come back for additional medical treatment, temporary disability, or permanency. A Section 20 dismissal is one that's one and done. You're full and final, it's with prejudice, and the case can never be reopened. The order approving settlement, when you go through the settlement process, is one where the claimant gets paid out over a period of weeks depending upon the level of injury that's been sustained. So in that type of settlement, all fees and costs are split. On a Section 20, the claimant, he or she bears all of those expenses by themselves. And again, that's a full and final settlement.
And with a Section 20, there's no admission of liability or culpability in the claim. You're just doing a full and final resolution.
Now, Section 20, as we started to discuss, is different than an order approving settlement. There's no award of permanency. There's no acceptance of any particular condition. There's no admission of liability. And there's no causal relationship admission. Basically, what you're saying is, I am going to pay you a lump of money. You are going to go away. It's almost as though this never happened.
And there's no ability to modify or reopen a claim that's settled under Section 20. And again, Section 20 provides full and final surrender of the rights to the claim. And these are difficult to obtain because, again, it's a full and final resolution. So you have to know the parties involved. And the New Jersey Workers' Compensation statute and workers' compensation in general is very designed to protect the injured worker. It's very, as we call it, petitioner friendly. Even if the employee, the employer agree, so respondent's attorney, petitioner's attorney, and the petitioner agree, it's ultimately up to the judge to determine if they'll approve a Section 20.
And there's a lot of times where that judge might not be your friend. And we'll talk more and more about judicial impact on cases as we move along. One of the important things of a Section 20 is the full and final, the one thing that I live by is the common sense theory of closed files are happy files. And if you can get a Section 20 and the claimant can never come back, you don't have to worry about other issues that we'll talk about shortly, but it's good for the employer and it's good for the insurance company. Now the next couple are going to be slightly repetitive because it's, number one, we wanted to make sure that we actually got 20 points to be able to address to you. But the first one is going to be that once you do a Section 20, there's no right to reopen for treatment. So the employee, no matter what the injury that they've had, when you Section 20 the case, their right to seek additional medical care, whether it be physical therapy, whether it be surgery, whether it be follow-up with doctors, or more importantly, attempts to follow up in regard to medication management has gone by the wayside. They basically agreed that the case will be over, they will not seek those things from you. And one of the things that we see, especially in New Jersey, is the cost of medicine and the cost of medication is going through the roof. There's also additional issues such as the opioid crisis that's going on in the state, and the inability of doctors to maintain control of that type of treatment for claimants. So if you can get a Section 20, all of those issues go by the wayside. Additionally, if the injured worker, or the petitioner as we call them in New Jersey workers' comp, ever attempts to come back, they're precluded from reopening the claim and trying to get any additional medical bills paid for once that Section 20 order goes through. And as you can see, one of the things that we wanted to bring to your attention is prescription medication costs. I have cases that are going on where claimants that haven't been able to we haven't been able to get rid of by Section 20, they have medication costs between $5,000 and $7,000 every month at 40 and 45 years old. So it could be forever before you get rid of them.
Another benefit of Section 20 is there's no right to reopen for temporary disability. They're resolving under any Section 20, the employee can't come back and obtain temp benefits if the alleged condition or injury keeps them out of work for a time in the future. So that's very key to remember. With an order approving settlement, you're almost guaranteed to have them come back and reopen and seek more medical benefits, more temporary disability benefits. As we like to call them, they're repeaters.
And as you can see, we try to keep things a little bit light, but you can see it by Mr. Scammer. He's laughing because he knows that he's got an open claim and he's going to take it all the way to the bank. Number 7. There's no right to return for additional permanent disability benefits. And that's really where you see the repeat offenders. The people that no sooner do they have their case settled under an order approving settlement, then within 6 months to 9 months, they're coming back and they're asking for additional treatment. They want to stay out from work because it hurts so bad. Or they want to increase, especially as you move further and further up the permanency chart, as you get closer and closer to the hump of 30 of total, where it becomes financially conducive for them to try and reopen because it could be a big windfall. So once you Section 20 the case, again, this is the third benefit, that they have waived the right to seek additional monies for. So if their condition worsens, they're either going to have to file an occupational disability claim against someone else or have a new accident to make more money.
Now, something to keep in mind is if a claim initially settles under an order approving settlement because the judge or petitioner's attorney and the petitioner won't agree to a Section 20, when they come back and reopen, which they almost always do, you can try and seek a Section 20 settlement on that. Now, if they request treatment and they go for a need for treatment exam and there's no need for treatment, you have an updated permanency evaluation, those are good indications that the claim should now resolve by Section 20. And
one of the things that happens in that regard is a lot of times you'll see people, especially the closer to the settlement, where the order approving settlement happens, if they seek treatment within 3 to 6 months and they file their reopener application, they at that point have to prove a material worsening of their condition. So if they come back and they go to a need for treatment exam and the doctor indicates that there's no additional need for treatment, they're going to have difficulty meeting their burden of proof to show that there's a worsening of the condition, which is one that can help us move towards a Section 20. Number 8, jurisdictional issues. Issues such as, does the employee work for the insured? Now, I'm not sure how many of you have seen this happen, but I have had a wealth of injuries recently where you're dealing with immigrants in an urban setting that are working on day jobs. And invariably, whoever picks them up and takes them to the work site, the person is probably not well enough trained and gets hurt on the job. And then the question becomes is, do they work for the guy who picked them up? Do they work for the subcontractor who that driver of the truck works for? Do they work for the general contractor or whatever? So a lot of questions have to be performed and asked, as well as information to be obtained to find out where do they work, who do they report to. You would be surprised how many people don't even know the name of the employer. They just know that somebody took me to work. Investigation is critical on these cases. So You want to be in touch early, especially on the claim side. You want to be in touch with your insureds. There are certain insureds, obviously, that will be more likely to present you with this exposure than others. Big national companies, big box companies, you're probably not going to see that. The more mom and pop organizations, you're probably going to see a lot more questionable practices. One of the things that happens on cases of either dual employment or in terms of who does he work for, is the burden almost shifts to the employer at that point, because the court system, knowing that they want to take care of the injured worker, will do anything and everything they can to be able to find coverage, to find employment, and to provide benefits. So if you are going to attempt to indicate that that is not a person that you should be paying benefits to, the burden is going to shift to you to be able to disprove the responsibility for doing it. So you want to, at the beginning and the outset of the claim, you want to make sure you do your investigation, and the stronger your proofs are, the more likely you are to be able to get a Section 20 resolution.
Another thing you need to take into consideration is whether the claim was filed in time, especially for occupational type claims. Did they file within the 2-year period where they knew or should have known that the injury occurred? So for instance, if someone went to their primary care doctor in 2005 and claimed their back hurt from doing their job at work, they leave the employer 5 years later in 2010 and then file in 2010 when they left, they would clearly be out of time for the 2-year period for the occupational claim. Joe, you had a case recently dealing with that issue, right?
Well, you know what? One of the hard things, and it goes back to what we were talking about, knowing your judges. Judges never want to see anybody get jammed up. So one thing that you might actually see is there could be situations where you have cases where frankly, you've got a dead bang winner. And what will happen is the judge will come to you and indicate, so the attorney on the other side doesn't get jammed up and have a malpractice case filed against them, to get you to provide some type of a minimal Section 20 so the claimant can walk away and get a couple bucks without feeling like they totally got taken advantage of or misrepresented, so they won't sue their attorney. So it's amazing the amount of power that judges have on each and every claim, because in that situation, there are times that we want them to lean on the claimant, and they might not do that as much as they might lean on us. So it's another reason why you want to know your judge. Another area that you want to be aware of, and you want to know your policy and work with underwriting, is, was the proper state utilized? In terms of your jurisdiction, you could have a claimant who has multiple jurisdiction aspects to their case. If they are employed in New Jersey and they're hired in New Jersey but they get hurt in Pennsylvania, they might be able to get 2 separate sets of benefits. So you want to figure out and know what your rights and remedies are. You also want to make sure, in terms of your policy, whether any accidents that take place out of state are actually covered under your policy. I have one now. The court, again, to cover the injured worker, is going to do its best to make sure that they find as much coverage as they can find, but it might provide you with wiggle room depending upon the level of exposure, and trying not to go to the appellate division or deal with the uninsured fund. They might try and work with you to massage a Section 20.
Point 9, questions of causal relationship. So you really need to see whether the injury resulted from the job-related accident. So was it actually job-related? The petitioner claims, I hurt my back on this date, January 1st, 2017. 3 months later, they come and say, I also hurt my hand at that time. Well, was the hand injury reported to the doctors when they were receiving treatment, or is the hand injury now something that's just totally new and not related to the work accident? We also want to look at whether the petitioner has a second job. Are they employed full-time with the insured and they have a part-time job at night working for somebody else, or vice versa? You need to research their employment, especially when they're part-time employees for you and working full-time for somebody else. You've had instances of that as well, Jim, right?
Yeah, absolutely. And you want to make sure you do your investigation on that, because you want to find out, are they doing heavy stuff? If a guy's breaking blocks or laying brick on one job, but he's answering a telephone on another, and there's an occupational case, you have a much better way to be able to go to a judge and say, Judge, let me pay a couple dollars and go away, as compared to being on the other side where you have the heavy lifting job with a bad back. And now all of a sudden you're trying to impute whatever liability you can point somewhere else. I think one of the other things that I've seen, and I know we talked about before, Vanessa, is when is the claimant making the claim of the second body part injury. Because there'll be instances, and this is where you want to do your investigation also, because you want to look at video. If you're working for a company in a warehouse and they have video cameras, you want to be able to look at that video and find out, did they really fall when they say they fell? Did they show any signs of injury? Did they grab one body part versus another? Because invariably what ends up seeming to happen on a lot of my cases, and I'm sure it happens with you, is you'll treat the back for 3 or 4 months, and then all of a sudden they're making a claim for a shoulder. And you're like, whoa, where did that come from? And invariably, they'll say, give you some malarkey that, oh, well, it really hurt all along, but my back hurt worse, so I wanted to make sure that I take care of it. So you want to have as many ducks in a row to be able to fight those issues of the ultimate later injury that probably never really happened. They're just trying to pile on. So if you want to look at the video or talk to supervisors or coworkers or things along those lines to find out really what went down. It's always easier to do it at the beginning of the case rather than trying to track it down the road.
You also, if I could jump in on this,
sure.
You also want to look at their hobbies that they do. Do they have a history of maybe going to the gym constantly and they're claiming shoulder injuries? Are they active on a softball team or a volleyball team or something of that nature and they're alleging shoulder injuries? You can do investigations to see social media, things along that line, to see how long they've been doing that activity and whether or not that is a potential cause of their injury.
It's funny you say that, because within the last year or so, I've actually had 2 cases. I was able to Section 20 a case where a guy had 3 shoulder surgeries, but my claim representative had done some social media work and realized that the claimant was a softball player. And she sent an investigator out, and they showed the player playing the outfield. Now, he ended up having issues in terms of his throwing mechanism because he couldn't get his arm up because he had the shoulder operated on, but he was able to swing, he was able to throw, and he was able to play softball. And we were able to maneuver a $50,000 Section 20 on a case that probably had value somewhere in the area of 100 to 150 with reopener rights. The other one, and it's funny that you were saying about social media, we had one where a claimant he worked for a company that delivered bottles of water. So he was carrying bottles 2 at a time, sometimes carrying crates with 6 of them in, a couple 100 pounds apiece. And what they found, he left our employee, filed an occupational case saying that he hurt both of his shoulders. And they went on social media and found out the guy was a beach volleyball player. And they realized, hey, if you're spiking or if you're digging and laying out and landing with your arms outstretched, you could very well do that. And that gave us grounds to get a Section 20 on a case with a guy with a partially torn rotator cuff. So, like anything, its investigation is key, especially the bigger amounts of money that you're talking about. Another area that you want to do your investigation on causal relationship and liability is you want to find out what the claimant's like, especially on cases involving stress or toxic substances. Do they smoke? Do they have other stressors in life? Do they have, are they involved in other areas? Are they running a private business of their own? Are they in the process of getting divorced? So they have the stressors of dealing with an ex-spouse or child support or child visitation, because all of those can impact your personal case and either aggravate it and make it worth more money or potentially give you a Section 20 resolution. There's no revolution there, I can tell you. The other thing that you want to make sure is that you totally investigate your private health care records to make sure that you know what's going on.
And as Joe mentioned, you want to see if they are a smoker. So in pulmonary cases, you want to know, have they previously had a pulmonary claim? Are they a smoker? When did they stop smoking? How many years did they smoke for? Did they previously have pulmonary treatment? You look into these records to see what you can argue is not related to the occupational claim. Also the stressors, again, is what's going on in their life much more stressful than their job, and is that causing more of an impact on them than the physical activities or the stress of the job?
Number 10, questions of dependency. And since I'm a smart aleck and I'm also living in the 80s, I saw this with Darth Vader and Star Wars and all that, and I thought, who's your daddy? Because Luke, I am your father. Dependency claims. Is the worker or the claimant actually related to the deceased? In New Jersey, there's no such thing as common law marriage. So that person, if that person is the common law wife or the live-in lover, they have no rights or remedies. If they have children, and it's this child of a live-in, that person would have to prove some type of dependence that goes beyond the normal statute. The other question that they have to prove is, how dependent are they? There are certain factors that are taken into consideration and presumptions of dependency, but the more information that you have to show, are the husband and wife separated? Are they living under different roofs? Is the child emancipated and living on their own? One of the things that I've seen that's worked fairly well is if a child moves out of the house to develop independent status, to save money on college tuition, is living in an apartment, has changed their driver's license, and uses a different state or a different town in the state of New Jersey, that might be a way to disprove dependency. So do your investigation on those type of things, and even one way or the other, you might be able to buy out on a Section 20 if you have enough good proofs.
Point number 11, questions of liability. Again, we're going to emphasize the statute of limitations on occupational exposure claim, 2 years when they knew or should have known. It's really important to do investigation. As Joe was saying, investigation is always key. Did they go to their primary care physician, as we were mentioning before, at a certain point and then didn't file within the 2 years? Also, lack of notice of the injury to the employer. Does the employer have a policy or program that they require the injured worker to report the injury? And did the injured worker follow the policy, but then the supervisor, if they have to report to the supervisor, doesn't follow through? And it's really doesn't have to be words. You had a situation like that, right?
Yeah, well, a couple things. First off, there could also be independent policies. If you mandate that your employee wears steel-tip shoes and they're not wearing steel-tip shoes, number one, you got to make sure that the employer provides those steel-tip shoes and mandates that the person wears them. But depending upon those circumstances, because they're violating a policy at work, you might have Section 20 capability on that. The other thing with notice and using notice as a defense, because the court is trying to make sure that there's as much coverage available for an injured worker, notice doesn't have to be the employer walking up and saying, Vanessa, I got hurt on the job today. You're my supervisor. I want you to know that I got hurt. I could walk up and say by chance, you're my supervisor and I'm dragging my leg. And you had seen me in the morning and I was walking fine and now I'm dragging my leg. And if you come back and just basically say, okay, Joe, I'm sorry, I hope you feel better, and you know, go home and ice it down, and you don't ask how did it happen, that could impute liability. But one of the things that you want to do is, if they're not forthcoming, or if the attorney's not necessarily familiar with that area of the law, you might be able to massage a Section 20 on an otherwise compensable case.
Very important point of getting a Section 20, the injured worker must be represented. Due to the fact that it's a full and final resolution, they're giving up any future perm, medical, temp benefits, and the ability to reopen the claim. A Section 20 cannot be approved unless they are represented by counsel.
I had a judge one time when I first got started 150 years ago, and I was arguing a motion, and he banged his gavel, and he says, Joey, my boy, remember one thing and one thing only in regard to New Jersey workers' comp. They call it New Jersey workers' comp, not Jersey employers' comp. So in situations of this nature, especially on a case where you're dealing with an unrepresented employee or an injured worker, the courts don't want that person to be taken advantage of. And they think that the rights to pursue a workers' comp case and potentially have reopener rights are so paramount of importance, that's the reason that they would never allow a case of a Section 20 to be approved without counsel's appearance. And technically speaking, there are times that we have cases. I just recently had one with a pro se claimant, and I kind of wink, nudged an attorney to go talk to him, because it was a case that it really was a Section 20, but I knew I wasn't going to be able to do it without an attorney representing him. So we were able to work that to make sure that we were able to get the Section 20.
Just to emphasize what Joe was just saying, a quote by Charles Dickens, but the mere truth won't do, you must have a lawyer. So even if you truly believe it'll be a Section 20 and the facts line up so that it is a Section 20, won't happen unless they're represented. Point number 13, good faith and Section 20. You cannot require an employee's resignation as a requirement for a Section 20 resolution. It's not allowed in New Jersey. In some other states, such as Pennsylvania, which neighbors New Jersey, you can do that, but New Jersey, they frown upon that. Another thing, just because the employee is no longer working for the insured, that does not give rise to a Section 20 resolution. Just because they've gone on to work for somebody else, if they had a specific accident at the time where they were working for the insured and they received medical treatment and they don't work for them anymore, does not matter if you have medical treatment. You know, there's no other issues regarding causal relationship or liability for that accident.
There's also situations, too, where you could see that on an occupational claim, especially if the medical records substantiate the fact that the claimant was complaining of problems, whether they be pulmonary or orthopedic, during the time frame when the claimant worked there. That becomes on a nuance then of how far back was it. If it's still within the 2-year time frame, you might be stuck with that under an order approving. So you have to do some work on that. If it's beyond 2 years, then you want to start talking Section 20 in that regard. One of the important things to understand, too, because the judges control all of this, and we can agree, if you were representing the claimant and I'm representing the employer and the claimant, and we all want to do Section 20, it still comes down to the judge. There are some judges that are strict constructionists of the statute. If you have no disputes aside from the level of permanency, so if you agree that an accident happened, if you agree that the claimant had a causally related injury as a result of that accident, they got treatment, they received temporary disability, and now your expert gives a permanency figure, so the question is just what's it worth? Technically, under the letter of the law, you are not allowed to Section 20 that. Now, there are certain instances where, and certain judges that you can maneuver on that, but there are also reasons that technically you're not supposed to be able to under the law. So you have to know your rights, you have to know the law, and remember, if you get one of those Section 20s that you weren't supposed to get, technically speaking, that's a gift. Don't expect that to be a right, that you're going to be able to do that all the time. And the other thing is, there's going to be certain times, and we'll talk about it later, that you might get the Section 20 with one judge, but if you're trying the same thing with a different judge, they're going to send you out hat in hand, and you're not going to get it, and they're going to tell you, tough luck, so sorry, it's only going to be by Section 20.
Just to reiterate the points on the previous slide, any failure to behave in good faith will negate any possible Section 20, and no pun intended with our little...
Oh, there was total pun intended, and Vanessa, I'm a little disappointed because you said that you were going to drive home the point. So, point number 14, partial Section 20s. This is a little bit different in New Jersey than it is in other states. In New Jersey, you can do a partial Section 20, but you can only do it on body parts. You can't do it on benefits. Now, what I mean by that, I know from having spoken with insureds who deal with different states, there are certain states that you can keep indemnity in a case but buy out medical of the same case. In New Jersey, you can't do that. If you're in under an order approving, you're in for a penny, you're in for a pound. And in certain instances, a lot of pounds. But what you're going to do is you're only going to deal with it for the accepted body parts. So when we were talking before about that, when you hurt your back and you dispute the shoulder, you might pay an order approving on the back, which means that they can come back for more treatment, more temp, and potentially more perm, but on the back only. So I can't buy out the medical on the back if I do an order approving. However, I can buy out the shoulder. If the shoulder's in dispute, we have medical questions. We have causal relationship questions. Maybe the person had an injury before, and we're claiming that our injury did not make that shoulder any worse. We now have a good faith basis to buy out of the shoulder and Section 20 the shoulder. So when we do that, we're going to buy out, when you buy out the shoulder, you buy out future med, you buy out future temp, and you buy out future perm. So remember, in Jersey, you can't buy out components of medical temp or perm, but you can buy out body parts that get brought in.
Something that we've alluded to throughout our presentation today is judicial discretion. So that, as we've pointed out multiple times, the judge is the ultimate decider on the value of a case and whether it can be resolved under Section 20. So again, even if respondent agrees, petitioner agrees, petitioner's attorney agrees, the judge can say, no way, no Section 20. And again, as Joe had pointed out, you could have different judges in the same vicinage having different opinions regarding Section 20. Some are very strictly construe the statute, others don't. It just depends, again. Know your judge, know your adversary.
And one of the things that you have to consider there are some judges, they would not, you could have the ultimate Section 20 case and they won't do it, which then leads you to, you're either going to pay on an order approving or you're going to try the case. So it gets really, really frustrating. There are other judges that are much more amenable and understand the circumstances of the case and why certain cases need to resolve by Section 20. Because frankly, there are certain instances where an insurance company or an employer will put money on a case to save on trial costs. But if the case actually went to trial, there's probably a pretty decent shot that they're going to win. What they're buying is the immediate closure of the claim at this point, rather than letting a case drag on for 6 months to a year while you're taking testimony over months at a time and then waiting for the judge to write up the decision.
And the judge looks closely at the issues we were just talking about previously: causation, liability, jurisdiction, dependency. So the judge will look at each of those things if they are relevant to a case to determine. If for some reason there is no genuine issue of causation, that would be a reason. If there is no genuine issue, then you can't do a Section 20. It would be an OAS. So kind of you have to lay everything out for the judge and for your adversary to not get.
Yeah, come on, judge, that just doesn't work. So you better make sure that you do your investigation with your medical. Sometimes you'll get thrown a bone that way. Get on social media to find out if the claimant's doing a lot more and might have been working and didn't tell you that they were working for someone else when they were working for you, or that there might be something on someone's Facebook page that talked about how they had gotten hurt outside of work. So those are really the ways that you're going to be able to do it. And it's really, if you don't have either a 0 from your permanency doctor or one of those big question marks, most of the judges are going to tell you, it's tough luck, so sorry, let's keep on moving.
And it's always better to be prepared and do that type of investigation that Joe was mentioning with social media and all that, with the primary care records as well, before you get to the judge. Because if you're talking to the judge and they ask, well, what did the primary care doctor say, and so on and so forth, it's really best to go in with everything in hand, fully armed.
And there are certain judges that will, when you go in with 2 experienced attorneys and the judge will say, is it a section, and we say, judge, this is a Section 20, some of them will just say, okay, and they'll just approve it, whereas other ones want to go and they want to review medicals and they want to be completely and totally thorough, because the last thing anyone wants to have is, egg all over their face because they didn't do it the right way. And frankly, that's the last thing we want to see when we're standing in front of a judge. Here's the new bane of our existence, Medicare. It's a shame it's actually 8 letters because it's a 4-letter word when we do our handling the files. Medicare, for those of you who don't know, and I don't mean to talk down to any of you who do know, Medicare is a federally governmental program that provides medical treatment to people who are either catastrophically injured and on Social Security disability or have reached a certain age. Because there are so many people on it, they are on the continual verge of bankruptcy and are doing anything and everything that they can to make sure that their interests are being handled and that they can find any source to be able to recover their monies. In New Jersey workers' compensation, one of the primary concerns for them, and one of the things that always needs to be considered when handling a claim where there's a Medicare recipient, is, are their interests covered? So when you find out that a claimant is on Medicare, the burden has recently changed. The law used to be that the claimant's attorney had to write to Medicare to find out, Medicare, did you provide any payments? What are called conditional payments, meaning that they're claiming that the treatment that got provided and paid for is something that they're entitled to reimbursement. That law changed within the last calendar year, and now the burden is on the employer to do that. So if or when you know or should have known that the claimant is on Medicare, the carrier should immediately write to them and seek conditional payments.
Can I jump in on that real quick?
Please do.
When the claim petition is filed, sometimes the petitioner's attorney indicates there's no Medicare, but you always want to look at the age of the petitioner. Are they at an age where they should actually be eligible for Medicare or close to being eligible for Medicare? And if the case settles within a year or two, will they be eligible for Medicare at that time? So it's always important to know the petitioner's age.
Absolutely. And one of the things that we do when we get our initial file and we file our answer and we send our letter of representation to counsel is we write to them whether they're of age or not to be on Medicare. We ask whether the claimant is currently receiving Medicare benefits, so that way we're out in front of it. Another thing that, although Medicare is a seminar unto itself, remember the law now states that if Medicare provides you with conditional payments, you have a certain time frame where you can dispute those charges. So if you receive conditional payments, carriers should get right on that to make sure that if there's any disputes that they're tended to, because otherwise it could be like the waiver of any disputes in regard to the Medicare issues. So that's one component that you have to do. And a Section 20 mandates that because under Section 20, you're full and final. So you have to, by law, take their issues into consideration, because if you don't, and you find out later that there were conditional payments, the carrier could be responsible or the attorney could be responsible, and there's penalties that could make it double indemnity, so somebody's going to end up having to pay it. So you want to be proactive in regard to it. Additionally, depending upon the size of the settlement, and depending upon circumstances on whether it's a reopener or whether it's just this particular claim, and Vanessa will talk about that in a second, you might need a Medicare set-aside. And what a Medicare set-aside is, it's a document and a program where you agree that a component of the claimant's settlement will be monies that they will use to set aside and to be used to pay for medical treatment before Medicare picks up off of that.
And one of the things you have to consider is if you previously had an order approving settlement and they've come back and reopened, and now you're trying to do a Section 20, you need to take a look at the prior award for permanency, the prior temp that was paid, and what you're going to pay on a Section 20 now, and does that equal or is that greater than $25,000? If it is, then you have to write to Medicare and see if set-aside is needed. The Medicare review threshold is $25,000. If it's below that amount, you don't need to worry about it. But if it is, with everything included on a prior award, have to write to Medicare.
And just remember, it's what is written on the physical document, the order approving settlement and or the Section 20 settlement. So if you paid med, but it's not the subject of a motion for med and temp, or it's not noted in that order, that doesn't count. If you provide temp, or you have a motion for med and temp fee, make sure that they're on something aside from the order approving settlement, because those are the numbers that Medicare looks at. The other thing with it is be really, really careful. Don't come in with a settlement that's $24,999 if you're paying any of the counsel fees or costs that bump you over that fee. So it's not just the indemnity that you're paying, it's also the indemnity plus whatever fees and costs that you contribute to.
Another thing to consider is continued employment issues. By law, you can resolve with an active employee a claim under Section 20. It doesn't matter if they're still active. It's more so a policy decision by any employer or insured as to whether or not they want to resolve a Section 20.
Yeah, the reason for that is, and I get it, I mean, there are certain employers who don't want people to file claims and get Section 20s and to be able to walk around and almost flaunt that they got the employer. Usually because in a Section 20, it's either going to be a small claim or it's going to be a disputed claim, and you don't want to necessarily sow the seeds where all of a sudden you might get a whole bunch of claims out of the woodwork. However, there are certain times where you really want to consider it, because unless you're going to be willing to try those cases, if all you do is kick the can down the road and give the claimant a little bit more money on an order approving and a little bit more on a next reopener, then all of a sudden you're reaching the hump of 30 of total where the money becomes big, and you're also it's almost like dangling a carrot in front of a rabbit, and they're going to chase it and reopen that case because they're going to know. And they're going to talk with people, and they're going to have strategies in certain employment situations. You see it a lot of times with certain employment areas or employment types of workers where, they're as savvy, if not more so, than the attorneys that they deal with. So a lot of times talk with your counsel to find out, is this one that we really should bounce on a Section 20, or is it one that we should kick down the road, or is it one that we should try? The one thing that I would strongly suggest, unless it's one that's so de minimis, if you're going to deal with a current employee, wait until you get your permanency report. The reason for that is a negative when you Section 20 with a current employee is that claimant can then still file an occupational disability claim that could tie you up down the road. One of the things that you do by getting your current perm report is you can make the argument, and in certain instances it's been successful with certain judges, sometimes not so much, but you can then use that as your baseline. So if you get your perm report on June 1st of 17 and it says you have this amount of disability, and then they file an occupational disability claim a year from now, my argument is unless their expert report shows a material worsening, that they haven't shown that their occupational disability claim has any value. So I always recommend, unless it's something that's so disputed and you can get rid of for $1,500 or something like that, to make sure you wait to talk Section 20 until you have your benchmark perm exams. So if you're dealing with somebody in the future that now all of a sudden you have a starting point that they have to prove that they can beat, because otherwise they might come back and say, none of that matters and this is what I want, and it could potentially hurt you.
Subsequent injury to the same body part. If you're the individual that had the back injury at work in 2013, in 2015 they have another specific back injury, you'd maybe want to do a section on the 2013 accidents and pay over on the 2015 claim. So you really need to look and see if there's two accidents to the same body part, what's the benefit of doing a section on the earlier one and paying on an OAS on subsequent accidents.
Yeah, one of the reasons for that is the first accident, because you have the second accident, it's insulated. So in reality, that condition that happened in the 2013 accident under your example is that condition can never get worsened naturally because it's already been worsened by the new accident. One of the things that you want to, a consideration that's a pro in terms of doing it by Section 20 is, number one, the petitioner is going to have to, or the injured worker is going to have to pay all those counsel fees and costs on the Section 20. The other thing is it allows your insured to remove reserves and not have to worry about deductibles on that second claim, because those a lot of times will run for counsel fees for us to represent them. So it could free money that that company could use on that 2013 claim. It's no longer encumbered, so they can put that into their cash stream and use it for whatever businesses pursuits that they need to do. There are some cons to that. I think they're manageable and you can get around them. Both of them kind of are intertwined. And it somewhat worked with what we were talking about before. If you Section 20 and you don't have a decent baseline or an expectation of what that baseline is, then there are some courts or the second injury fund that might say, you Section 20 that. That doesn't mean there was any value affixed to that Section 20 figure. It just means that you were getting rid of it full and final, no more problem. So one of the things that we routinely talk about is to put your agreement in writing with the attorney that you're doing it with, because you want to make sure that if down the road they try to come back and try and screw you and say, well, whoa, we never agreed with that, you've at least got it in writing.
Something along the lines of, we've agreed to a Section 20 settlement of X dollars, which is approximately the equivalent of 7.5% of partial total or something like that. That gives you something to work with in the future if they're going to come back and maybe do a fund petition.
Absolutely. And sorry, Vanessa, I stepped on your toes on that one.
It's okay, Joe. I'll forgive you that time. Another issue is the death of employees during the claim. So if there's no dependency claim, there'd be nothing to reopen, there'd be no further permanency. Perfect reason for Section 20. You look at the size of the Section 20 to see, did exams take place? Do you have a determination of what the possible permanency could have been? Who could possibly testify as to the physical activities or conditions? Was the person married and they passed away? Could their spouse come in and testify that they were always in agony and pain at home, or something regarding their mental state at the time of their passing, so you could have fixed the permanency for Section 20? Again, the judges are very petitioner friendly, so they might be looking to help the estate, so to speak, with regards to a Section 20, so they want to see what the PERM report said to see if they could put a decent dollar amount on it. As workers' comp is, it's always in favor of the injured worker.
Yeah, one of the things to consider with that too, and it kind of goes along with what Vanessa was talking about, the judges are people, and when you hear the word death, related or not, especially if there's a surviving spouse, or especially if there are surviving children, that judge is going to do anything and everything they can to try and take care of those people. And they're going to try and make you pay as much as you can within reason, because otherwise, in most of those instances, they've lost the primary bread earner of that house. So, and the more liberal judge, the more likely they are to lean on you to pay more money. So some of that you have to, obviously, if you haven't reached the point of exams, that's beneficial to you. If there wasn't a lot of treatment, that's beneficial to you. And so there's going to be a lot of factors and a lot of strategies that you're going to have to work. But I think the one thing that Vanessa's talking about that I totally agree with, just because the claimant passed away doesn't mean that you walk away and that you get away without having to pay. The question will be is how much and how do you work your case as well as you can to make sure that you don't have to pay as much as you fear that you would. Number 20, subrogation. For those of you who don't know what subrogation is, and I don't mean, again, to talk down to anyone, subrogation means that if an injured worker got hurt on the job, but it was the fault of someone else, that you can go, whether be the claimant or you as the carrier or employer, can go and seek damages against the person who hurt your claimant and get some of the money that you gave back. So a lot of this is going to be sensitive, and it's interesting in terms of how it deals with Section 20. Section 20 is covered, the subrogation statute is covered under Section 40, which is NJSA 34:15-40, and it deals with subrogation, your rights to recover, how you recover, and how you maneuver towards resolution of your subrogation action. I think I stepped on your toes again.
I'll finish up this slide. Section 40 allows for you to recover up to 2/3 on any med, temp, or perm paid, less an additional $750, which is usually the cost to the third party. And we see these subrogation cases a lot in motor vehicle accidents where the petitioner is injured. But rarely people get back 2/3, right, Joe?
Yeah, you know, what ends up happening, and a lot of times we have to rely upon you in claims to deal with this, because claimants' attorneys a lot of times are fairly shady. They will try to go to you to negotiate settlements and reductions of your liens. So you have to make sure on your end that you deal with your defense counsel to make sure that the wording of any agreement on Section 40 for the subrogation monies is properly taken into account. Routinely, what I've seen over the course of my 150 years plus an hour, is that invariably the claimant or the claimant's attorney cries poor mouth, and they try to get you to negotiate your lien. Usually go 1/3 to the claimant, 1/3 to the attorney, and 1/3 to you. Make sure that you're careful when you write those up, that they understand that your rights don't end at that time. I have a case now where the claimant pulled that nonsense. It was a $6,000 Section 40 lien, so we got $3,000 back instead of our 2/3, which would be $4,100. But in the letter, it indicated that that was full and final. Now, the claimant made $50,000. I'm looking at a case that has value of upwards of $25,000 of total, which is another $40,000 on top of it. So technically speaking, we potentially have lost upwards of $26,000 of negotiating aspects to it. Now, one of the things so always be careful if and when you're dealing with subrogation on your end. There's 3 different ways that I think that you can go, and 3 ways to consider, but if you ever have a problem or a question, you should reach out to your counsel. Number 1, if it's a really crummy third-party case and you don't expect to make any recovery, there are times that you might say, you know something, I'll pay you X under Section 20 and I will waive my lien. So I will never ask you for dime one of your third-party recovery, but I'm going to take less and get a Section 20 and I'm done with you. So that's one way to go. There's another that, frankly, it's very, very rare, which is the second one noted on the handout. I've only had it twice in my career, where I've reserved my Section 40 lien on the med and temp, but I Section 20'd the perm. The beauty of that is by Section 20'ing the perm, technically speaking, at that point, they can't reopen the case, but whatever med and temp that I paid for, I might get some of those monies back. And usually, you might pay a little bit more under Section 20 knowing that you're going to get some of those monies back. That's really, really rare, but it's something to consider. And then the third thing that I think is really important is make sure that when you're negotiating your Section 20, that you understand the value of the claim, to make sure that when you're negotiating your Section 20, you might not want to negotiate it at full value. You might want to look at it and say, I'll pay you 2/3 of full value or 40% of full value, or I'm sorry, 1/3 of, because you get 2/3 back. But I might pay you at 40% and waive my lien. So make sure that you understand all of the machinations and all of the dollar impacts in terms of how you do that and how your subro rights are affected by your Section 40 lien.
Well, that concludes our webinar. If there are any questions that came in?
It does not appear that we had any questions, so that means one of a couple different things. Either we bored you and you got off the webinar, or number two, we taught you something that you already knew, or hopefully we gave you a lot to think about and you don't have anything. But we wanted to thank you for participating in our seminar today, or our webinar, and we hope that you got something out of it.
We do have some upcoming webinars, November 14th, Defining Injuries in Pennsylvania Workers' Compensation Cases, with some colleagues from Pennsylvania. December 19th, Top 10 New Jersey Workers' Compensation Cases of 2017, presented by our colleagues Mark Sotaro and Cheryl Benosa. And if there are any questions, our contact information is at the very beginning of the webinar, so feel free to reach out to us.
And we'll get back to you as quick as we can. The other thing is, if you look on our website, we have old webinars that are on our website that you can access them and maybe potentially learn about some circumstances or issues that you have questions on. So we want to thank you for participating in today and hope that you enjoyed it. Have a great day.